Hi, I'm Jackie Hutter, and I'm here to tell you why I think that everything that you know about patents is probably wrong and why it should matter to you as someone who leads a company. Before we get into the meat of my presentation, I first want to have you understand my perspective. I've been in this business for over 25 years now, and the path to get to where I am now has been somewhat different than probably most folks who are in the patent business. I started as an IP litigator, and as an IP litigator, I either tried to knock down somebody else's patent and saw the flaws in the way to do that, or very often I was trying to hold up my client's patents that might have been kind of lousy and mistakes were made. So when you do something like that, you tend to look at the flaws that can be built into patents from the inside, from your lived experience, more so than if you haven't done that before. After doing that patent litigation thing for a couple of years, I moved into patent prosecution. And patent prosecution is probably what you're most familiar with, in that I talked to inventors, I understood what they had invented, drafted a patent application, and got it through the patent office. I did very well at that. I did that for a few years, became a shareholder in a prestigious firm, and I found it to be kind of boring at the end of the day because it's the same stuff, different day. And what I really disliked most about it was that I didn't see the effect of what I was doing every day. Everything was kind of in the abstract and just kind of pushing paper, if you will. They're an expensive paper pusher, but I push paper nonetheless. And so I took a big risk. I jumped off and I went to a large consumer products company where I was brought in to help them reformulate their patents for a particular type of consumer products. And what I learned very quickly when I went to the corporation, that unlike when I was a law firm lawyer, where everything that I did created value from patents, very little, if anything, that I did at the corporation actually had anything to do with revenue generation. And I realized that in order to really find success and to be effective in that role, I had to figure out how to align what I did as a patent expert with the revenue generation process. And that was a new experience because, like I said, everything that I did when I was a patent lawyer and created revenue for my law firm, but I wasn't in the patent business anymore. I was in the consumer products business. I had to rethink the way I did things. I did that for a couple of years, and as things would happen, I was out on my own, and I had to figure out what I wanted to do. And I knew that what I had been doing at the corporation, trying to align patents with business value, was what I really wanted to do. I liked seeing my products on the shelf. I liked seeing what I was doing make a difference in what was actually happening in the real world. That was not true when I was a patent lawyer. So I created this new business model in this as a pioneer, quite literally a pioneer in this world of IP strategy, and figuring out how to articulate how to create business value from patents. In the meantime, I kind of took a sidetrack and became a startup technology CEO. So I, from the inside, tried to find investment, bring technology to market, and that was not, that was not the greatest experience, not because it wasn't a great experience, it was because that I was pretty much a better IP strategist than I was a technology company CEO. And a friend of mine who actually had been my mentor said, Jackie, you're better. Will you help me build IP for my new startup company? And and I started moving into helping entrepreneurs, helping innovators create business value using patents. And I've been doing that for about 7-8 years now. And I've got a lot of perspective that I can share with you because I've seen and thought a lot about the way the patent system, the patent attorneys, the patent industrial complex, as I like to call it, does not serve the needs of business today. So I want to be clear here. I'm not criticizing. I'm not intentionally criticizing my colleagues in the patent world. Patent strategy is a different business model than the the patent world, the IP world, the IP law firms, and people are doing the best they can. We didn't create the system. We have to operate in the system, and understanding what the problems with the system is what can make you more effective. As Ice-T said in 1999, don't hate the playa, hate the game. So, no criticism to my IP attorney colleagues, many of whom are friends. It's not your fault. It's not my fault. It's just the system does not work for everybody in the way it needs to. So let's talk about the numbers, because as business folks say, if you don't measure something, you can't manage it. So these are some numbers. People can quibble about whether or not they're correct or not from year to year, but let's just say that these are the numbers that we have right now. About 650,000 patent applications are filed in the US every year, and about 325,000 issue, about half. Patents cost anywhere from, if you're talking about simple, about 8,000 to about 15,000. And this is out the door. This is filing, prosecution, and issuance. Only single patents. If you have multiple patents, of course, it's going to cost more. Average complexity patents, 12,000, 25,000. And complex patents, the numbers that we see are about 20,000 to 50,000. Of course, the law firm you hire is different. The type of technology makes these numbers different. But these are pretty much where you can say that you'll land with each of these. Most of my clients end up in the complex category, although not anywhere near the $50,000 number there. I love this chart because this chart is based upon real insights by some really smart IP strategy people. And years ago, I don't know if this still exists, but years ago, there was, if you will, a mastermind group of IP strategy professionals from some of the largest corporations in the country. And they would get together periodically and discuss IP within their organizations in a non-confidential way to share best practices, to try to be better. Again, these are the biggest companies in the world, the biggest patent filers. So they should be the best at what they're doing. So there was a survey done, and the book is Edison Boardroom Revisited. They did a survey to find out what these companies, the best companies in IP, how they gauged their patent value. And what it turned out being was that only 5% of the patents that these companies were getting were considered to be strategic. And as I understand it, strategic means that these are patents that actually affected the competition in the market, that actually made their competitors do something different. About 20% of patents had some value, and by some value, as we'll see later, these patents covered a product that was in the market and some reasonable facsimiles thereof. So they did cover something that somebody would buy, but there was not a whole lot of value created by these patents. And 70% of patents created no business value at all. And what I like to characterize having no business value is patents that don't cover anything that anybody would want to buy. So if you line these patents up against what patent attorneys make, it's kind of telling here that if only 5% of patents create strategic value, market-making value, 25% of patents create some value, and 70% create no value, patent attorneys actually get paid 200%, because not only do they get paid for the patents that issue, they get paid for the patents that don't issue. That great market, right? Great business model. So patents really matter, but when they matter a lot. And the key is to know when this is the case. So I like to break down the subject matter of patents into what I call inventions and innovation. Most patent filings are directed toward inventions. Inventions are incremental improvements to an existing product. They tend to be iterative R&D aligned with the company's core competencies. And they're typically extensions of existing technology. A new product within a line, a new and improved product to do an improvement to an existing product. Inventions tend to fit into established markets. Companies already have customers, they already exist, and the companies know how to serve them. They know what to do to make them happy. Of course, hopefully they do. Otherwise, they're probably not going to be in business long, but they know their customers. The intent is to enhance the revenue streams and exclude competitors from selling the same product. Or reasonable facsimiles thereof. So that's what the patent coverage is directed toward, the difference between the prior art and a new product. The point of reference when you're patenting is whether it's novel, that is new, and whether it's unobvious. And the key to craft coverage, your patent coverage, is to protect the output, the end of the R&D process. Actually, patents matter very little to revenue capture when it comes to inventions. If the market's not big enough, then why would anybody want to knock you off? So if nobody's going to want to knock you off, why would you get a patent? How sustainable is that product in the market? What I learned when I went to the consumer product company was that some of our products only had a life cycle of 9, 12, 18 months. And by the time the patent issued, there would really be there was no life left in that product. And so why were you patenting something that wasn't going to have any real longevity in the marketplace? And if your competitors are not going to respond to your product, then there's really no reason to patent it. So those are typically what we look at, in the invention realm. Innovations are very different. Innovations are not new products; they're new solutions to a customer problem. Very often, you don't know what the customer problem is, so you don't know what the product is. You have to iterate to find that product market fit, to find that customer, to find that product that will serve the customer. Innovations are not always new technology. They may be new collections of existing technology. You'll hear from some folks that Steve Jobs wasn't really an innovator because he took existing technology and put it together. He didn't invent anything. Well, sure, that's maybe the truth, but those previous inventions, those previous technology were sitting out there for anybody to use, and nobody wanted them. So the way he put them together to provide a new solution to an existing customer problem was an innovation. So you can create old technology and put it together in a new way and have it be an innovation. With an innovation, you're looking often at a new market, totally new market, didn't exist before, that has to be created, or a new way to serve an existing market with something that hasn't been there before. The customers may or may not exist today. They may not even know they need this, so they may not be obvious. The intent when you do this is to establish new sources of revenue that have not existed before, and to exclude competitors from serving those same customers. In other words, to get paid back for your hard work of establishing customers, establishing new markets. It follows that your patent coverage must be effective to keep competitors away from that solution, not the product. The product is actually irrelevant in all likelihood to what problem is being solved for the customer. So your patent coverage must allow you to protect that solution. Importantly here, unlike inventions, innovations are by definition patentable. They're new. They've never, because the solution has never been, this problem has never been solved before. And also, if it's a big problem and it hasn't been solved before, of course it's unobvious or non-obvious when you solve it, right? So the key is to craft the the patent coverage, to protect the market opportunity, not the product. If you protect the product, you may leave a lot of the opportunity on the table. Patents are very often critical to revenue capture in the context of innovation, because the competitors will want a piece of the action if the market is large enough. And importantly, if you establish that the market's there, that the customers are there, that it's scalable, if a competitor comes in behind you, it's going to cost them less to compete, because they not only can use your customer validation, your market validation to establish for them that their risks are less, so there'll be less risk, so they'll make more money in the main, but also they can use you as a roadmap to solve the same customer solution. So I tell folks that when you're innovating, you have to make it cheaper to go through you than around you. So let's bring this to a practical example. And this is should be something that resonates with most folks. So in 2015, there was a lot of hullabaloo about this new aluminum body F-150 truck. Oh my gosh, it's totally different than what's come before. Yes, this was a truck that was now made out of aluminum, but at the end of the day, it was a truck. It did exactly what a truck did. It may have gotten better gas mileage, but it's still gas mileage was still an internal combustion car truck. It also was lighter and all the things that went along with it, but it was still, at the end of the day, was a truck. On the other hand, we have an innovation, which is the 2023 F-150 all-electric Lightning, which is about to be introduced. This is not a truck. This is a battery pack on wheels. This is an energy vehicle for a work site. This is a way to energize a work site. This is a battery pack that moves people. This is a battery pack that moves equipment. Yes, it's a truck, but in reality, it does something totally different than a set of totally different objectives. It solves totally different problems than the prior F-150s did. And I don't do Ford's patent work, but I hope that they have characterized their patent coverage in a way that reflects the true innovation that this truck is as a battery pack on wheels, a worksite electrification mechanism. So over the years, I've kind of tried to figure out why things go so badly for so many patent attorneys. Why I was so many patentees, not patent attorneys, because patent attorneys always get paid, right? And what it's come down to me is I've realized that very few companies actually have the degree of internal expertise needed to get them to the right place. And I didn't realize this until I actually went to work at the corporation. Did I realize what I saw, what I did, and what my roles and responsibilities were vis-a-vis my client, my employer, were versus what they were when I was a patent attorney getting paid for patents and managing people to do that. And so if you see on this chart, you'll see that only one type of company really has enough work, enough staffing capability, enough need perhaps to have in-house counsel that's managing their IP internally, strategically, hopefully strategically. But we also have other types of established companies. Remember, established companies are those that have business models, they have customers, they don't have to worry about where their next revenue stream is coming from because they're established. They can be large, medium, and small. Most of these are working primarily in invention. Occasionally, they'll have an innovation. That is like the F-150 with Ford. But typically, they're developing revenue and they're moving forward in that realm. Different from established companies are early stage companies. They do have business models. They do have companies. They're typically have started as startups and now they're starting to scale. Still early, they could still pivot, they can make wrong turns, things can still happen. They're not fully baked, as it were. They tend to be small, and they'll also use outside counsel, but they're also working in the innovation realm, especially since they've come from startups. Startups, in all likelihood, have no business models, or if they have business models, they're still really, really shaky on that. Very often they will pivot. They tend to be small and micro. They have outside counsel because why wouldn't they have outside counsel? The last category of patent filers are inventors. They have an idea. They don't have a business model, and most of them, in my experience, have no desire to go out there and build a business model. They think they're going to license their idea and get rich. And there's a lot of companies out there that will play on that expectation, on that hope, and it really doesn't happen. This is a story for a whole nother presentation, but we're not talking about those folks here. This is where I spend my time. I spent my time in these other categories previous to becoming an IP strategist, but I work in the innovation realm for these companies that are really making a difference. They're solving unmet customer needs with new technology or new products that are embodiments of existing technology that is put together in a new way. So how do you know when your patents matter? Well, your patent only matters if it helps generate your desired business outcome. What are you trying to do with this patent? Hopefully you're not just trying to get a patent. You're trying to get a patent that accomplishes some business objective. Possible outcomes, the typical one is, I want to keep my competitors from selling knockoffs of my product. So basically what you're saying is, I want to go out there once I get a patent and fight. I want to stop somebody from doing something. Well, you've got to be pretty ready to spend big money on lawyers, because when you get set up for that type of adversarial situation, you're going to be spending boatloads of money on lawyers. You also need to understand how the competitors will respond to your product. Are they going to really care that you're out there? Like I said previously, it's like, well, if your competitors are not going to sell knockoffs, then why would you try to prevent them from selling knockoffs? And importantly here, you can't just get any patent if you're going to quote unquote protect it. You need to get better patents that understand not just that contemplate not just your product, but also how your competitors might understand your product and how they might react to it. Because going out there to bring a not very good patent, again, in litigation, ends up costing you a lot of money and probably not getting you a very good result. But I tell folks that if you're talking about protecting your product, you're probably aligned with making lawyers rich, or you're in a large corporation that's got lawyers, and if they're not working on litigation, they're not going to be there very long. So different incentives. I tend to look at those other types of situations where patents matter. And sometimes what you want to do is create market complexity. You want to make it so that your competitors have to figure out how to respond to your patents. And that can be for big companies, that can be for companies of other sizes. Companies also, especially in the startup space, might want to get patents to technology signal, right? Because they can show, by showing what they're doing, and not all of what they're doing, by the way, but that's a conversation for another time. You don't have to show everybody's. You don't have to show your competitors everything if you do this the right way, but you can show them, you can signal your technology is real, it's meaningful, and you intend to get patents that cover it. In this case, numbers can be good, but it can get very expensive very quickly. And I see a lot of companies trying to just get the numbers up without really understanding what the numbers are doing for them in the aggregate. They tend to what I call carpet bombing as opposed to doing guerrilla warfare, which is what we'll talk about in a couple of minutes. I prefer my clients to do this more guerrilla warfare approach to patenting. My clients that are startups tend to do best when they're thinking about their patents as collateral for deals. I would really like the tagline that BASF, the chemical company, had for years. We don't make the stuff you buy, we make the stuff you buy better. That 1 + 1 = 3, that you are creating a technology or a product that goes into somebody else's product so that you become indispensable to them. It creates revenue because you're getting revenue that you don't have to get from investors, so you don't get less dilution. Also, you can enhance market valuation, because if you can explain to your investors what your strategy is and how that creates value in a competitive set in your marketplace, you can improve the valuation so that you have less dilution if you're taking investment, or you can get a better exit. So let's talk about some specific clients that I've had, still have. They're still very, very important clients to me. So I have one. This was a newly minted PhD and a seasoned CEO. who I met back when I was in my startup days. And in 2014, you have to take the Wayback Machine. The new PhD says, hey, I think that I can come up with this new way to do automated construction measurement. You couldn't really at the time get accurate measurements from images that you took of construction sites. So we didn't file immediately because we did not know what the product was. Because we were still trying to figure out whether there were any customers, and were there any customers? There wasn't a product yet, so we had to iterate to get that product market fit for a few months, and eventually, after about 9 months or so, we together decided, hey, this is good. It looks like this is something that customers will buy. Let's protect it. We quickly got patents through the accelerated process in the patent office. We started getting some investment in revenue. By 2016, the market was telling us, our customers were telling us that we think you'd be really great helping us measure the interior of buildings for various reasons. And so we said, great, we'll file a patent application built on the technology we developed that would be potentially applied in measuring the interior buildings. Turned out that market did not develop as quickly as we thought it would, and we needed to pivot in order to develop revenue so we could stay in business, because we're a startup, right? You got to find a customer, or else you don't really exist. So in 2017, we moved to using drones to measure the exterior of buildings. Well, the patent application we had filed in 2016 actually also covered drones, because when we were filing this patent application, I pushed my team to say, if we have to pivot, where would we pivot? Why would we pivot? And what would be needed in those markets? And remember, you should remember that my startup customers, all they do is talk to clients. All they do is talk to customers, so they hear things that other folks don't hear. And we included all that information in the patent application, and we continue using that patent application to create new filings that go back to 2016, and we predate everybody else in the marketplace because we thought about it first. And not only did we think about it first, we patented it first. So now the market's all in artificial intelligence, drone inspection, and visualization, and we have been creating patent applications back for several years, and we now have the predominant patent protection to meaningful products and technology in this space. And this was a true guerrilla warfare process. We didn't spend a lot of money, or definitely didn't spend anywhere near as much money as we're getting from value from these patents. And I'm hopeful that this company is going to have an exit soon, using the patents as collateral. Company two is, these were two young tech entrepreneurs. They had in their graduate program identified a way to use digital imagery, to diagnose a common cancer treatment side effect. And so they figured if you could diagnose it, the treatment would follow. Well, in their conversations with customers and in their actual testing of the product with patients, they found out that there was a need for the companies that actually sold the medical devices to treat this problem to actually get better ways to measure the patient for these medical devices. And very early on, the patents had we accelerated the patents and they were able to license their early patents as medical device company, so that the medical device company could sell more of the medical devices. We continued the filing as a result of their innovations, because they were out there listening to the patients, talking to the customers, figuring out what was needed, and continued to do this walk forward. And we continued using their insights to file. And there was no prior art out there. Nobody had ever done this before. And so now we have moved into the realm that's just emerging into AI, artificial intelligence, medical device fitting, and condition monitoring. And we've got multiple patents here. And because this company had generated revenue from licensing their patents, they didn't need investment. And so they didn't have to take dilutive capital, or as much dilutive capital as they otherwise would have needed. They've been able to stay scrappy and responsive to the market without creating the ecosystem necessary to generate the investment that other companies at their stage need. Company 3 may be, for those who aren't startups, company 3 may be more in line with what you're familiar with. So this was a CEO technologist that was seeking an exit in a few years. And all my clients, this guy has a superpower. He's got this just unique way of looking at the world that allows him to solve problems in his relevant market. Same way with my other clients. Every one of them has a superpower because they're able to develop insights and deploy those insights to solve big problems. So this guy's no different. Been in the business for a long time, wants to retire, but he wants to retire by selling his business at a number that makes sense for him, that allows him to get paid back for all of his hard work over the years. So he realized that he should probably get some patents on his unique insights. So in 2016, he identified a low-cost firm that would file some patents for him. One of the patents was to a monitoring innovation that was looked pretty cool. He wasn't sure if it was going to work, but heck, he was going to file it, and if it did work, it would be something that would change the nature of the monitoring environment. In 2018, he got his first patent allowed. Fortunately, like a week before the patent got issued, he found out that he better have somebody come in and take a look if it was a good patent. It turns out it was a lousy patent claims, that it wouldn't really cover anything because the low-cost firm was not incentivized to create value, as we'll hear in a second. They were incentivized to help get the patent out, if that. I said, whoa, we gotta refile this. We gotta file better claims, and we did, and we got that patent allowed. We also realized that, hey, if we could do this monitoring a better way, we can get data and we can build that into an automated artificial intelligence treatment monitoring. And we've patented that. Still not in the marketplace, but we're looking at the future, right? That's what innovators do. They look at the future. And what has happened in the last few months is that the monitoring innovation has become an industry standard. When plant managers are speccing new plants or plant upgrades, they are saying, I want company 3's patented, or they don't really care that it's patent. They want this improvement. And every project that goes into place today is saying you've got to have this innovation in there because it works much better that way. Well, my client it has the patent to that. And so now we're sitting in a situation where if we're going to either be able to develop or demonstrate sustainable value for this company, that is that somebody that comes in and buys this company will be able to create sustainability even after the CEO is gone, because there is a patented innovation. That's where we care. We take licensing that can be done with strategic partnerships with some of the other folks that are in adjacent parts of this market. But bottom line is that having a good patent to this innovation that is now being adopted in the relevant industry, this CEO has optionality that he did not have before, and that optionality is likely going to result in greater value for him at exit. So now let's move into what I call patent myth busters. Like why some things that you probably think are true are in fact not true. And I know you think they're true because I thought they were true before I got in and started looking at things from the inside of the patent development world. So first, patent myth number 1. Patent lawyers will first assess a client's unique needs before providing patent advice. This was a big one for me. This was like something that totally turned my life upside down, and I'm not kidding about that. What I realized is that the things that I learned, the things that I was taught, not just the things that I was taught, the things that I was required to do were based upon assumptions that of what what inventors, what patentees, what companies needed, but were in fact actually outliers to what the typical client, inventor, or whomever needs for that. So let me explain. So when we learn rules, when we learn laws, we learn all of this stuff against the background of what went wrong in the past. Something happened in a litigation and it was bad. Or something happened in the patent office and the patent examiner messed up. And there's actually very few fact patterns that actually end up creating a global rule for global rules for us. And so we go in and say, this is the way you do it. You don't vary from this, and you have to follow this rule. When in fact, that rule is only applicable to some clients, and actually sometimes very few clients, which is rather amazing when I thought about it. One of those examples is how you file a patent application. You file early, you file often, you do all this stuff because you may lose your opportunity to gain patent protection if you wait. Well, yeah, that's great in a world where your customer, you're developing inventions as a result of the output of an R&D process, and you have core capabilities that have led you to that point. So yeah, of course, you're ready to file at that point. And all of the rules are associated with what you do and don't do against that environment. But a startup, if they file too early, then they may be filing for patent protection on a product that nobody wants to buy. And so the best thing for many startups, at least at the early stage, is to wait as long as possible before you call go. But actually, you're not selling anything at that point. You're out there figuring, if you're getting the right advice, you're talking to somebody like me, you're not selling something, you're actually putting it out there and testing it, which is a totally legitimate reason to wait to file. So, so my startup clients differ from a large company, those large companies or established companies that I've represented in the past. So I need to give different advice, but in order to give different advice, I have to know that the advice they need, the context is different. Similarly, those folks that are filing for inventions need different advice than somebody is filing for innovation. And I take that all into account before I talk to somebody and give them advice. Of course, I'm always working with innovators these days, which makes the advice more similar, although the clients are different. But you still have to be able to parse the differences between clients, not just their size, are they large or small, but also what they might need in order to affect their business goals in context. 2, your patent team is ethically required to ensure that your issued patents are valuable. This blows people's minds, okay? And there's a story about this. They're not required to do so. There was a case a few years ago, and it's just the way things are. We learn from cases, right, in my business. An inventor came up with something really cool that made a drill better or something like that. And he got a patent. He hired a good patent firm, expensive patent firm, and got a patent. And he took that patent to Black & Decker. Black & Decker said not interested. Sometime later, Black & Decker came out with a product that had all of the function as the product that the inventor had brought to them to license, but it did not infringe the claims. And we know it didn't infringe the claims because the inventor spent gosh knows how much money taking us all the way through litigation, and the jury came back and said does not infringe. And so he was quite not surprisingly angry that he hadn't gotten patent claims that protected the innovation, or what I could characterize as innovation, because Black & Decker was doing the same thing that he came to them with, at least from functionally. So he sued his patent attorneys. And the patent attorney, this also was litigated, and the court said, hey, your patent attorney doesn't have an obligation to get you a patent that has value. You are responsible for that. You, inventor, are responsible for telling your patent attorney what you need. And you just go, wow, okay, that kind of stinks. But when I was doing a conference a few years ago, I was in a room with probably 75 really experienced high-level patent attorneys from both corporations as well as from law firms. I was up on the dais talking about this as part of the presentation I was doing. And I asked folks in the room to raise their hand whether or not they thought this was a bad result, that the patent attorney had no requirement to get valuable patents for the client. And I'm not kidding, every attorney in that room raised their hand and said it was the right result. Even those inside of corporations, which is kind of crazy if you think about it, because they should know better. But just be aware of the fact that the incentives are totally different for your patent attorneys than they are from you, than they are likely are for you. Third, patent myth: you can't engineer patent outcome. I'm sure that some of you who are listening to this have rolled your eyes or even been upset when your attorney, be they a patent attorney or otherwise, when you ask them a question, they say it depends. So it's like everything's uncertain. What can you do? I don't know what I'm going to do, and that leads to the belief, the understanding that you can't get the outcome you want, that you cannot hold your patent attorney, your patent team accountable, and that's absolutely not the case. My clients, we are getting broad patent coverage within a year, plus or minus, some even less than 6 months, because that's the outcome we want. That's the outcome we engineer. Other clients, we take it a little bit longer. We take different, and sometimes we take different. We engineer different outcomes for different situations. As one example, one of my clients had a really breakthrough way of solving a problem. And it was just literally, it was like, oh my gosh, it went from 10 steps to 2 steps. And they were bringing, as a startup company, bringing the solution to the marketplace and developing strategic partnerships. They didn't want everybody to see what they were doing. And so that meant that we did not want to accelerate our patent filing so that it would become public in roughly 1.5 years. So what we did instead was filed for non-publication. You could just check a box on your patent applications in the US and say, I don't want this published. And that patent application stayed confidential for close to 4 years, because it took forever to get out of the patent office. And once it did issue, and by the time that it issued, we were fully embedded in other companies' products. The BASF thing, we made their products better. And so they could not disengage themselves from us, because not only were we fully embedded with them, we actually had patent protection. So if they tried to do the same thing with somebody else, we would be able to deploy that patent probably in a deal situation with the third party that would prevent them, our longstanding customer, from getting done what they wanted to get done. So we engineered a specific outcome in that case. Patent myth number 4, patent strategy means the same thing to you and your outside patent team. Absolutely not. When I was a patent attorney, strategy meant to me, yes, I did patent strategy, but patent strategy is when I filed, what I filed for a particular client, how I managed the process through the patent office, and all the stuff that went along with patents. Where you stand depends on where you sit. And when you're a patent attorney, you sit at the place where, how are we going to move these patents down the playing field? That's very different than from when a business person thinks about patent strategy, because a business person wants to know how the patent strategy is going to affect, it's going to result in their business strategy being affected. So make sure that when you're talking to a patent attorney about patent strategy, that you're talking about the same thing. It's definitely a Mars and Venus thing, and now that I've made you see this, you're going to be aware of it. So make sure that you double check to make sure that they're on the same page as you are. Next, the better the firm, the better the patent team. Absolutely not the case. And this is something also that I learned when I went inside the corporation. We had some of the most expensive law firms in the country, and some of the biggest garbage that I had seen from patents. And what I saw was that a lot of firms, even though some of the best firms, use clients that aren't paying attention to train their associates, to churn, to get value in. If you're not watching what your patent attorney is doing, how do you know that your patent attorney is doing the right thing for you? Also, a lot of folks who use law firms for other things like transactional or tax or whatever, they say to their existing counsel when they need a patent, can you send me to a patent attorney? And the person who's an expert in tax or transactions or or whatever doesn't necessarily know that somebody in their firm is actually good at patents. So you really can't tell whether or not the person that is doing your work in patents is really good or not. And I wish there was a way to give you signals to look for. I really can't. I actually did some research on this a couple of years ago, and I and another really sophisticated patent prosecutor, we had to throw our hands up. And we wrote an article. Basically, we threw our hands up and said we can't tell you whether somebody's good or not. So it really is a crapshoot. There's no other way to say it. But as long as you're aware of this, you can manage against it going forward. Patent myth number 6: when my patent team listens to me, they're actually hear what I'm saying. This is not the case. When you tell somebody that you want something to be done with your patents vis-a-vis or in relation to your business, your patent attorney may have absolutely no clue what you're talking about and therefore how to implement it. There's a story about this. It's actually a very sad story for the client. So a few years ago, I was brought in as a second opinion. And this client was a CEO technologist, had a superpower, just really brilliant. It was kind of really cool what he was doing. And he had been working with a large company a few years earlier and trying to get a strategic partnership together. And it didn't work out. And so he found out years later that this company was called Bad Guy because it's easy for you to illustrate what they are. So Bad Guy had not only not worked with him, that they had not only stolen, if you will, his technology, they had also filed a patent application on which he was his technology. So he should have been named as an inventor. And so he was quite rightly, and to add insult to injury, the patent application that he had filed was still pending in the patent office. Really weird. But it happens sometimes. And his patent attorneys had been pending for 4 or 5 years, whereas Bad Guy had gotten their patent allowed in a couple of years. So he said to his patent attorney, "Give me a litigator at your firm. And what I want to do is to take a litigation strategy that will get Bad Guy to the table as soon as possible." So his patent team listened to him, but they didn't hear him. And what they ended up doing was filed, when he came in to talk to me and asked if I had an opinion, I said, they have taken a litigation strategy that is the one that is least likely to get the other side to the table. It's the one that's going to be longest, it's most fact-based, and this is the exact wrong way to get somebody to the table. But even worse, the Bad Guy's attorneys had clearly been told by their client to make it as painful as possible for the CEO. And they were filing what I considered to be spurious motions in the federal court, which was caused because you have to respond to all these motions, these motions that were, quite frankly, for bogus things. But they weren't, they didn't break any rules, but they were not good faith litigation, in my view, that was costing this client more money, costing the CEO more money. And what was even worse than that was that the clients, the CEO's patent counsel was treating these filings made by Bad Guy's attorneys as if they were made in good faith. It was good faith litigation, which was absolutely not the case. They were trying to increase the pain on the client. And I told him this. I said, listen, you're not going to get them to the table. These guys are doing it the wrong way. And if that's your goal, it's not happening. So they were fancy attorneys, and they were able to convince him that their way was the right way. And it's like, fine, he didn't take my advice, and it's like, I'll just move on. A few months later, I found out that he was really excited because his lawyers had won on appeal in the appellate court. Now, the reason this issue had gone up to the appellate court and why he had won, or why the lawyers had won, was because it was a spurious argument that had never been made before. And so it was a case, as we say, it was the first time the case was ever held. The appellate court was compelled to rule on it because the issue had never been heard before. But the reason why it had never been heard before, because it was a dumb issue. So yes, the client prevailed on the appeal, and the case went on. But in order to get to that space, that spot, it cost him tens of thousands of dollars. So yay, they won, but he still was not in the place where he wanted to get these folks to the table. They had no reason to get to the table. And in fact, they didn't want to get to the table, as shown by their litigation strategy. Fast forward a couple more years, and this is actually fairly recent. For whatever reason, I don't even remember why I did it, but I went online and saw that the case had reached a point where the CEO's attorneys, the ones who had given him the litigation strategy that I had said that was the wrong one, had actually filed a motion before the judge that said, "Hey, we want to be out of this case. We're no longer going to be working for this client. Oh, and by the way, he's seeking to settle with the defendants, or the defendants, and we have no idea why." And you could tell, you can read between the lines of this motion to see that the things had not gone well, and they were no longer friends. They were no longer on good terms. And what was really sad for me was that this case had gone on for as many years as it was. There was obviously the CEO had bled money all this time and not gotten the result that he had wanted originally. And at the end of the day, he ended at the same place, settling with the other side, settling with the bad guy, but he was settling because he had to, not because it was a good business result, which is how I read between the lines. And I guess this gives me some degree of satisfaction, but it still makes me sad, is that my contact who had originally sent me the CEO as a client for the second opinion said that, yeah, he recognized that that what Jackie told him was exactly what was going to play out. It played out exactly the way it played out, and he was regretful he didn't take my advice. Well, I take no joy in the fact that the CEO didn't listen to me, because he was an entrepreneur with a superpower, really cool stuff. I knew a little bit about the area. It was just like he just had this really cool way of looking at the world that I thought made a big difference in the market. And surely he did, because the bad guy was stealing his stuff, right? And if he had taken a different tack, his patent team had taken the tack that he wanted, he perhaps could have been spending this money on creating even better technology over the years and serving his customers, as opposed to paying his lawyers. And it's, again, really sad. And you see these things play out in a way that makes you not happy that you're right. But at the end of the day, I've seen this time and again. And patent, if it track it up to not understanding, chalk it up to misaligned incentives, chalk it up to just people not caring. But very often, your patent team does not really hear you when you talk to them. So I'm going to sum things up now, and I appreciate your patience here. I say all the time that the definition of strategy is defining the desired endpoint and working backward. So what are you trying to do? Why are you doing anything, be that in the realm of patents or anything else for that matter? What do I want to accomplish? And then and only then, when you have that mapped out, do you create a plan to get there? Now, your goal may be just to get a patent, but really, if you ask most people, you say, "Do you want a patent?" And they say, "Yeah." It's like, "What are you going to do with it?" There's a lot more stuff there. What do you want to do with it? So it's not getting a patent. It's like, what do you want this patent to do for you? So I've created this handy dandy chart. You can screenshot this if you'd like, to create. So this is how I recommend that folks create patents aligned with their business outcomes. First thing you got to figure out is, do you have an invention? Do you have an innovation? Because how you approach both of those things are very different. And then it's like, what business goal do I want to accomplish with this specific patent, which may be different than the last patent you got, or most of the other patents you've got, because it's each of these decisions has to be made independently. Now, it may be that you have a strategy. Once you've defined it, you already have a strategy that you follow. But unless and until you have a set of options associated with the business outcomes, then you shouldn't be moving forward. So once you have that, you determine, how do I craft patent coverage that allows me to achieve this objective? Okay, and that sets up how this patent coverage is going to be developed and defined. You have to vet and select a patent team that understands and can meet your business objectives, and that should be clear by now. It's Mars and Venus. People, they may listen to you, but they don't hear you. So you have to make sure that they're the right ones for you. And then this is super important. I think this is where a lot of folks fall down also, is that you have to manage your patent team and hold them accountable for results. If you don't hold them accountable for results, then you're not going to get the right results in most cases. Like, as an example, I'm filing a patent up. I told you about the example of that client where we were measuring inside a building in 2016, and then we pivoted to measuring outside a building from the air a year later. If we were not directly managing our patent filings at that time, we would have ended up with coverage that was directed toward a business model that we had pivoted from. And instead, we were able to go in and reformulate our coverage, recraft our coverage, so that we were covering the business model that was aligned with our pivot and also our future revenue drivers. And you have to do this. I know patent attorneys can be really hard to deal with. We like talking about stuff that nobody else is interested in. Hey, I'll raise my hand there. That's just what we do. We're patent geeks. But you still have to learn enough about the system, about what you're trying to do, and how your business objectives can be aligned with what your patent team is doing, so that you can not only manage them, but also holding them accountable for results. So thank you very much for your attention. Feel free to reach out to me and ask me questions. I also have a podcast called Winning with Patents and IP on Spotify, iTunes, and any other podcast sharing platforms. And also, I have been writing on patents and IP strategy for close to 14 years now. I have quite a few writings on my LinkedIn page. You can also find my podcast link there, as well as on my blog that I don't populate anymore, but there's a lot of ruminations from the first 6 or so years of my doing this as an IP strategist that may be able to provide you with some guidance and insights into your own patent business strategy. Thank you very much, and take care.